But why is it you submit an appeal against Lincoln? You have support from 1, 2, 3, 4, 5 doctors. You have additional objective medical evidence. You have a functional capacity exam. You have lots of other evidence. So say you have 4 or 5 sources saying our clients, or this claimant's disabled. Now the insurance company gets the claim. They hire one medical professional to review the file, and then 9 out of 10 times or 99 out of 100 times they adopt the opinion of the one medical professional that they hire. Why is that, and is that reasonable and allowed by the law?
It's, in my opinion, is not reasonable. It's ridiculous. That you could have 9 versus 1. Let's say 9 treating providers. Actually, the treating providers not only are giving support for this person's claim, but they actually meet with them, evaluate them, and over a series of months or sometimes years, they know this individual and they can give a pretty good opinion, an idea whether this person has the ability to perform any occupation or their own occupation or what their restrictions and limitations are, rather than this one doctor who is first off, he's paid for, or she's paid for, and secondly, most of the time, all they're doing is reviewing medical records. They call it a paper review. They're not actually seeing you and seeing your complaint. And what they do is they go to your medical records, they highlight something where it says normal or mild, and they stress that, and then they send those reports to the appeals specialist. And they use it to deny the claim. It's not a fair situation. The case law allows them to do this because a lot of times, I used the term arbitrary and capricious earlier. The standard to win these lawsuits, not only do you have to prove to the insurance company that you are disabled, you have to prove in many jurisdictions that the decision to deny your case was arbitrary and capricious. And what arbitrary essentially means, everyone kind of knows what the word arbitrary means. It kind of means random or without thought. So if they have a reasonable basis to deny your claim, technically they should win the lawsuit. The insurance company wins the lawsuit. So they have one doctor who says this person is not disabled. They say, Judge, we had a reasonable basis. This doctor said this, and that's why we rely upon this doctor. But we do a good job with our lawsuits and with our motions for summary judgment to obviously show the errors in those doctors' ways and why they're being unreasonable and giving those opinions.
Right, and the good news is there's many states that have abolished this discretionary clause, which is a line within the policy that says the disability company has the discretion to administer the policy and interpret the terms of the policy, which thereby tells the court, hey, you have to apply this arbitrary and capricious standard. But a lot of states have found it so unfair to claimants that they've said to insurance companies, if you're going to do business in our state, you're not allowed to have these discretionary clauses, and therefore, if your cases go to court, then the court's going to look at it, what's called a de novo review, fresh, and make a determination as whether or not they think the claimant's disabled.
Right.
And in those situations, the claimant has more of a level playing field because now the court can look and say, okay, I see the 5 doctors from the claimant. I see one doctor who maybe didn't even look at the client. And how am I supposed to reconcile this? I got 5 people saying claimant's disabled, 1 saying no, and this person didn't even look at the claimant. So those cases are a lot easier to win than when the court's hands are tied and basically says, yeah, I see 5 on the claimant side, I see 1 on the insurance company side, but I have to look and say, was it a reasonable review by this doctor? And fortunately, it's hard for the insurance company to say it's a reasonable review when they don't even look at the claimant. They don't necessarily, these hired doctors don't go into great detail saying why they disagree with the treating doctors, and there's a lot of arguments that can come up to win at the litigation level.
One big thing is you don't know what documentation they actually were sent from the insurance company to review, and you don't know what documentation they actually reviewed. Sometimes they put a list in there and they list, 5 or 10 documents that they reviewed, but sometimes the insurance company, I feel, does not give them a well-rounded picture. They should send them the entire claim file. It's going to take the doctor hours to go through and summarize, but that's one of the issues I see a lot of times, that I see that they're not getting the entire record.
Okay.